Hey, Paul here, and in this video we're going to discuss the differences that apply when a married person leaves their spouse either ownership of their estate or leaves their estate in trust for their spouse or leaves the usufruct of their estate to their spouse. Okay, had way too many conversations over the years of people just thinking, oh, I left my estate in trust for my spouse so my spouse can do whatever they want to with it. Or my husband left me usufruct so I can do whatever I want to with it. And really, I have to kind of go back and clarify a bunch of stuff all of the time. So let's look at an example where, let's say someone lived in Louisiana, which is where I'm a lawyer and where I have my estate planning law practice. And particularly I'm going to address the Louisiana usufruct, which is a form of ownership unique to Louisiana. But you folks outside of Louisiana, you can also get all the benefits of learning the difference between leaving ownership and leaving things in trust for your spouse. Okay, so let's just use a simple example, one that probably would never apply in the real world, but it allows you to understand things. Let's say a husband, he had a will and he died, and the only asset that he had was one or more bank accounts that had $500,000 total in his bank account or bank accounts. We're going to disregard all the community property stuff. His estate, $500,000 cash in bank accounts. So now I can use that example to really help you understand the differences on how he could leave things for his spouse and potentially for his heirs or for his children. So in example number one, let's say the husband in his will said, he could have said either, I leave my estate to my wife, I leave ownership of my estate to my wife, I leave all of my property that I own when I die to my wife, I leave everything that I have when I die to my wife. Could have said any number of those things, all indicating that he left ownership of his estate to his spouse. So he dies, they go through the probate proceeding, the judge signs the order, wife is to be the owner of everything husband owned, including the $500,000 of cash. That money goes to her, it gets put in her bank account, she owns it, she can do whatever she wants to with it, she can spend it, she can invest it, she can leave it to her or their children, she can leave it to their grandchildren, she can leave it to charity. She could leave it to a new husband that she gets after her first husband died if she wants to. She's the owner. She does whatever she wants to with it. Most people understand that concept. Leaving ownership to your spouse. Sure, husband might have said, I leave ownership of my estate to my spouse. And further in his will, he might have said, if my wife predeceases me, I leave my estate to my children. But that's only if his wife predeceased him. Since he died before his wife, that $500,000 goes to her. She does whatever she wants to with it. Now, maybe she set up a will at the same time that said, if my husband predeceases me, then when I die, I leave my estate to my kids, and it'll wind up going to the kids anyway. But she's the owner. She can do what she wants to with it. I think you get that. Number two, let's talk about the Louisiana usufruct here for a minute. Again, it's, in Louisiana, we're different. And so we have this form of ownership called usufruct. And now let's say husband died, he had $500,000 in one or more bank accounts, and his will was different. His will didn't leave ownership of his estate to his surviving spouse. He left, I'll call it the lifetime usufruct of his estate to his spouse. And when he wrote a will and left usufruct to his spouse, he also needed to name what's called naked owners. Who's going to get those assets when the surviving spouse's usufruct terminates or when the surviving spouse dies? He said he wants his two kids to be the naked owners. So he writes a will, leaves the lifetime usufruct to his spouse, names his two children as the naked owners. He dies, they go through the probate, and then what happens? Well, that $500,000 goes to the surviving wife. She puts all of that money in her name. She, under our rules, she becomes the owner of that cash. Cash is called a consumable item. She becomes the owner of it. However, she has an obligation when her usufruct terminates to the naked owners have a right to $500,000 when she dies. So let's go through and answer a lot of the questions that I always get when we explain, what happens in those circumstances. He dies, he left his wife usufruct of his estate, which was $500,000 of cash. It goes into her name, and maybe she buys a house, maybe she invests it, maybe she keeps it cash. But let's say when she dies, she has an estate of $800,000, and maybe it's cash, maybe it's real estate, maybe it's stock, maybe it's vehicles. Well, when she dies, her estate owes his two naked owners the $500,000 that she has the usufruct of. Now, there may not be the cash in her estate, so maybe her house needs to be sold, maybe her cars or her investments need to be sold to account to the naked owners and to satisfy what we call that usufructuary accounting. So if she had an $800,000 estate when she dies, his two kids get the first $500,000, and then her heirs get the remaining $300,000. Now maybe his two kids are the same heirs as her two heirs. They get the whole $800,000, but his naked owners got to get the first $500,000 that she's got. Her heirs will get the remaining part of her estate. And then the question we always get, what if that $500,000 isn't there when she dies? And let's say she spent it. And let's say when she died, her entire estate was $300,000. Well, her estate has this debt to his naked owners of $500,000. And if all she has when she dies is $300,000, that's all they're going to get. Now, her heirs will get nothing, but his naked owners will get the first $500,000 that she has in her estate to the extent she has it. Okay, and so under the usufruct, the usufructuary's estate owes that amount to the kids. If he left her the usufruct of cash, or what's called a consumable item. I'm going to get into that a little bit more in a minute. All right, now let's look at a third example. Let's say, and this could apply in all 50 states, let's say he left his estate in a trust for his spouse. He left his estate to the husband trust with, and this was all in his will. His will said, when I die, I leave my estate to the husband trust. I name my wife as the trustee. I name my wife as the income beneficiary. I name my two children as the principal beneficiaries. And I allow, or the trustee has the ability or discretion to use the trust principal for the income beneficiary or for wife's health, education, maintenance, and support. That's kind of a common way for spouses to leave their estate in trust for their surviving spouse. And then he dies, he has $500,000 in cash, and then that money, after the probate is done, goes into a husband trust account with wife as trustee. So she's the one who has the signature authority over the account. It's in a trust for her. She gets the income that it produces. If she needs to use the principal for her health, education, maintenance, and support, that HIMSS standard, which is common, she can use it. And let's say she does. Let's say she uses $150,000 of that $500,000 to meet her ordinary, living expenses. She lives another, 5, 10, 15, 20 years, and she needed to use some of that $500,000 that was originally put in the trust. So when she dies, there's only $350,000 left in that trust. Now, she may have other assets of her own, but what the husband left her in trust for what she needed to use it for, there's only $350,000 left. So when she dies, then the principal beneficiaries of that trust get whatever's in the trust. And in our example, they'd get that $350,000. So in the trust example, if the surviving spouse spent some of the money that was in trust for her, then that just reduces the amount that the principal beneficiaries will get when that surviving spouse dies, as opposed to the usufruct, where the surviving wife becomes the owner of that $500,000, but if she spends some of it, she still owes his children $500,000 from her estate when she dies. So that's the distinction between the usufruct and the trust. Again, the ownership example, real easy. She owns it. She does what she wants to with it. She leaves it to whoever she wants to. So so those are kind of the scenarios there. It gets a little more involved, I got to tell you, when there's different kinds of assets. We just talked about leaving $500,000 of cash, but some different rules can apply, in particular with usufruct, when someone leaves the usufruct of a home or shares of stock or vehicles. Slightly different rules there than just the rule of when you leave cash. So hope that helps you really better understand the difference between leaving ownership versus leaving usufruct versus leaving things in trust in your will if you're married, particularly if you live in Louisiana and you have this usufruct option. Hope that gives you a better understanding of what the ultimate consequences are by determining, which type of bequest is appropriate. Okay, we'll see you next time.